Hi everyone, welcome to An Hour with LawSikho. Warm welcome to all those who have come to watch this and would be watching on our YouTube channel later. Please do remember to subscribe. Today we have with us Nikhil Borwankar, who has Borwankar, right?
That's
Am I
the one.
getting the name right? Okay. So
That's all
we
right. I'm the first one to get it wrong. It's okay.
So we have with us Nikhil Borwankar, who was an assistant prosecutor in the 2G scam case, and he's a criminal lawyer, and he has been doing many different things, and an upcoming successful criminal lawyer. And we would be hearing from him today about his experience with the 2G case, and also about his experience as a criminal lawyer and litigator. So a very warm welcome, Nikhil.
Hi, thanks. Hi. Hello, everyone.
Thank you for joining us on An Hour with LawSikho.
My
So,
pleasure.
to start with, why don't you tell us a bit about yourself?
Sure. I can start with my name. So this is a funny thing because if you look up my name, you will find many orders get my name wrong routinely. I've been called Borgaonkar, Borkar, Bor Bhayankar. There's all kinds of names that are out there, but it's a difficult thing for me to look up my own orders sometimes. But that's how it is, I guess. That's those were the cards I was dealt, and I'm happy to carry it forward. So my background is a bit, it's a little different from the norm. I used to be, I'm an engineering graduate to begin with. I used to be a software engineer for about 4 odd years. I switched from software to law in around 2011 is when I began full-fledged practice, and I moved to Delhi. And when I moved to Delhi, I began as an intern with Justice Uday U. Lalit, who was then senior counsel in the Supreme Court. And I suppose he must have liked my work because I went from intern to junior, which I didn't know until then was a distinction. But then I became his junior and I assisted him through the 2G prosecutions from day one, in fact, until he was elevated to the Supreme Court as a justice. And thereafter, I continued with his successor, who was also appointed by the Supreme Court as the special public prosecutor, that was Mr. Anand Grover, also senior counsel. And I assisted him during the 2G prosecutions, whereafter I have started my own practice. Actually, about 3 odd years ago, I went completely independent. 4 years ago, yeah. And I have been since then practicing in Delhi, and I've had the opportunity to also practice in several high courts around the country, and that's my background in brief.
Okay, so that's quite an interesting journey. So, but tell us a little more about how did you come to be a litigator? Why not, like these days the trend is that people want to work as corporate lawyers, people want to work in big companies. What made you want to become a litigator, and why criminal law?
Hmm. Okay, so there is a why did I start litigation? Okay, so as I said, I used to be an engineer, and what happened is that during my days in software, I suppose to some extent wanted a little more excitement and drama in my life, and if you watch any of these legal shows, uh, the practice or Boston League and all, it was pretty dramatic, right? I mean, when we were growing up, we used to watch shows like that, and I thought, okay, this is interesting. But it was never really a thought that I would actually end up practicing because I went into the stream of engineering and I was very interested in software, and I worked for 4 years pretty hard. I even had a small jaunt in the US, which was a typical software trajectory, where you aspire to go to the US and you get into that lifestyle. But when I was in the US, I suppose I had this realization that this is not the life for me, that I want to do something direct to engage with society more directly, and to really test my boundaries and my limits, and Public speaking was something I always enjoyed, even growing up. So one day, when I was, in fact, I recall one particular instance when I was reading a newspaper article about Justice H.R. Khanna and his judgment in the ADM Jabalpur case, which is a famous case on habeas corpus. I remember reading it and remarking, why is Justice H.R. Khanna not exalted nationwide, worldwide? Why aren't there statues to him in every chalk, in every gully? And I remember verbalizing these thoughts, and my mother, who was just, I suppose, ambling around in the house, stopped, looked at me, and said, "Well, why don't you do something about it?" And I said, "All right, let me see what I can do." And so I got around to try to researching what he did and who he was, and I read his books, and I read books about him and articles about him and about his time in the context of the ADM Jabalpur case. And I thought, this is really exciting stuff. This is democracy in motion. And I thought, okay, well, where does this rabbit hole go? And then I just tumbled down that rabbit hole like Alice, and I found the wonderland of law, and I said, okay, litigation seems to be the most direct form of engagement with society that seems to excite me. So why don't I think about this? Because I'd already been in a corporate job in software. That was corporate. It was completely uh, it was a very well set corporate pattern, like your Infosys or Wipro and something like that. And I'd already determined that that is not the life for me. I want more directness, and hence litigation.
That's a very interesting story. But I'm wondering, like, I think many of us wonder from time to time, given how exciting technology is. When you know how to make a software, it's I think somebody, Mark Anderson or somebody, said that software is eating the world. And from that perspective, I think like software, people who create software do change the world. So did you never feel that in a way you are living a great opportunity that is there in front of you?
That's actually a very, very profound question. It's insightful, and I'll let me explain. There is a joy in creation. Undeniably, there is a joy in creation. It's fulfilling, and that is also why I enjoyed my software days. I used to be a programmer. I used to Java and Ruby on Rails and C++, and that was my core competence. And in fact, I used to be a hacker, and my soft in my software exploration, I used to leave frequently with a toothbrush. I'd leave my home with a toothbrush and a towel, a hand towel, and I'd return 72 hours later, um, fairly knackered because I'd just been on a 72-hour coding binge. And it was very exciting creating the things that we did, because we were actually working on a product when we realized that the Indian software space is dominated by services and not products. And we realized how involved and intricate the software development lifecycle is. And I lived that life cycle for a product all the way up to it was version 6 by the time I left. And yes, there was a joy in that creation. There was an excitement in that creation. But there was a part of me that read the newspaper every morning and was exposed to certain elements of our society that the general population isn't, because of the atmosphere at home, where my mother and father both were uh, union government officials. My mother was in the police, and my father was in the IAS. And I had seen, uh, in a sense, the administrative side of democracy, and I had learned how these things work. And I suppose that there was a part of me that litigation specifically appealed to, as opposed to the joy of creating software. And it was a difficult decision, I'll tell you that. It was not an easy decision, uh, which is why I suppose I stayed in software as long as I did, because I had in fact contemplated switching to law in my second year of software engineering. but I never really did follow through with that. And I finished my engineering in 4 years, and then I went on to software, and I lived that lifestyle for a while. But there was something, perhaps growing up, perhaps in my background, perhaps a part of my core, that litigation specifically appealed to. And it was a difficult decision to make, because litigation, you may have heard, is seldom rewarding when you're starting out with it. It takes a while before it really gets going. And it's taken me that time and those years of experience and hard work, but I have enjoyed every single moment of it. And I can tell you, there is a joy in creating a practice, and it is the same joy of creation that I had in software, except that I feel that I am now more directly involved with uh, with the administrative aspect of society than software.
I think Nikhil, what you are trying to talk about is that you have a personal impact on a lot of people when you are at the court, when you are arguing cases, things that decide the fate of many people often, and creates policy for the country or creates impact on the entire nation sometimes. And that's a very fortunate part of being a lawyer, right? Or even one person sometimes you impact. And I think that's quite a great experience of being a lawyer. Is that what you're saying?
That is
When
part of
you
what I'm saying, because there is a, without sounding vain, there is, or at the risk of sounding vain, there is certainly a more direct impact on a person to person level in litigation. But there is my desire, or choice of direction in litigation was actually less motivated by impacting people's lives directly, and more, yeah, I suppose, more with a greater focus on, or emphasis on, impacting the machine of democracy, the machine of our society. I suppose it's an engineer's mindset. I suppose it's an engineering mindset, that I want to tinker with the engine that runs our democracy, to see if it can be run better, if this engine can be more finely tuned. And my practice in that sense has everything I've done since I began practice has in effect been that way. So I see of course, a necessary corollary to my actions is the impact upon the fate of my clients. There is absolutely no doubt that it is a direct impact. But my motivation is more to tinker with the engine, if that makes any sense.
right, I got it. I think that makes that tells us a lot about the kind of motivation that made you choose litigation and the kind of practice of law that you have been probably building. So, what has been the journey like so far? Also, like I want to ask you, since you have been a software engineer, why not do more cyber law or like those technology law aspects? It seems that, I mean, I don't know, you might be doing that. Can you tell us a little more about that? I would imagine that having done so much coding, you'd understand the intricacies of that side better.
Oh, certainly. So, here's the thing: my life is not short on irony, and in that sense, it's also not short on luck, because my optional subject in my fourth year was, I mean, I had the option to choose between artificial intelligence, which was exciting, and human computer interfaces, which was exciting, and maybe one or two other subjects. And then there was this other option, which was telecommunications engineering, and I chose telecom. And at that time, this is 2006, I think. And in 2006, India was beginning its journey and experiment with 2G. And when I began practice, literally day one, my first day in practice was in the matter of the CBI versus A Raja, which was the 2G case. And so I was uniquely predisposed to understand the technical aspect of that case, and it was an exciting ride, I'll tell you that. And so I suppose my opportunity met intent and preparation. So I was lucky. And in that process, thereafter as well, I have practiced in criminal law. I have had the opportunity to deal with offenses or allegations in which a substantial portion, and in some cases the fate of those allegations and fate of that trial was dependent upon the technical aspect. So for instance, I can give you two illustrations off the top of my head. In one particular case, the allegation was of rape, 376, and during the investigation phase, I can tell you this is one sad part of practice. The investigating officer of this particular police station in Delhi had demanded 5 crores from my client to let him off on a charge of rape. This is how, I suppose, things work in this country, and my practice has taught me a lot of the ground realities of life, and this just happens to be one of them. And it turned out that the police officer, the investigating officer, was well aware that the allegations were being made by a lady who is, the words that he used were a habitual complainant. This was her fourth complaint of rape against. So she had 3 previous complaints of rape against 3 other individuals, and it was an extortion racket. And if you read the news, you'll find that this is not even a new thing. For me, of course, it was a new thing at that time. But so one of the key pieces of evidence in that case, in order to absolve my client who was innocent, one of the key pieces was that the complainant, the lady, she had used the investigating officer's laptop and internet connection to send herself an email, believe that, from my client's account, because she had the password, threatening herself. And this is a difficult allegation, or this is a difficult proposition to substantiate. If I was even able to clarify what I mean, the lady, the complainant, used the investigating officer's laptop and internet connection to send an email to herself from my client's email, and then took a printout of that email and carried it to court the next day and said, look, my client, that is my client, the accused, is threatening her, and therefore he should not be released on bail, and therefore the rest would follow. And it took a lot of investigation from an IT perspective that I did in order to find out whether this proposition was true, that whether she had in fact used the whether she had, because the direct implication is that she was colluding with the investigating officer, the IO. So the IO and the complainant were colluding, and
find this out in the first place. How could you find this out, that it has been sent from the investigating officers?
Good question. So if this allegation is true, that the investigating officer's laptop and internet connection were used by the complainant to send herself an email, then if you translate this into the digital world, into the internet world, what this would effectively mean is that one internet connection, meaning one IP address coupled with the MAC address, the machine access code address, coupled with the subnet mask, if you can work it backwards, would uniquely identify this one particular device from which the sender and the recipient of the email are the same. So if I had the logs of the internet service provider that provided the connection to the investigating officer, then in those logs, at a particular time that can be found from the email header, at a particular time, there would be only one machine, one unique machine, or one unique mobile directory number that maps your internet connection.
No, I understand that part, Nikhil, but what I'm wondering about really is that, how did you start going into this direction? Well, was there any reason you thought that that normally she could have sent it from some other email also, some other computer also? I mean, that's quite a lucky piece of evidence to find. So
yes.
How did you stumble onto this?
Right. So that's one step before what I'm describing. So what we had done before that is, because my client was sure that he had her, that she had her his email address and password, because we knew that he had a lot of evidence of their 2-year long relationship, after which she had accused him of rape because he refused to pay her money. He was a US citizen at the time, and she wanted to get married to him and move to the United States. And when he said no to marriage is when she went ahead and complained of rape. And in those circumstances, we had, because he was certain that his that she had his password, we had already obtained the what is known as the cell phone location, the tower location, using the cell phone records. And at the time that she had sent the email, she was squarely placed in the police station. She was in that police station at that time.
You had a opportunity to like you got this through the court through a court order, I suppose.
Well, let me put it this way. I shouldn't reveal how I got the information I got, because that may jeopardize certain future interests. But let's just say I got this information, and it's just something you have to do sometimes to get this information. But all of it was legal. I can tell you that. I can assure you, everything we did was legal.
Interestingly, we had recently a lot of cases going on in Mumbai, especially over lawyers trying to obtain call detail reports. And like I myself happened to write one article for First Post about this. I had a request that, can you review this situation? So, this definitely, I'm very curious, because usually you get it through the police. Like police have access, on the commissioner usually have access. Interestingly, this brings to me another question that I intended to ask you, and I ask all the criminal lawyers who come on An Hour with LawSikho, that do you also hire private detectives sometimes? How does this work? Because from what I am hearing, that it's a lot of detective work as well, apart from pure legal work. Wouldn't you say?
Oh, absolutely. I have actually physically gone to locations and to hideouts and places that are significant it's a de facto investigation. Let me put it this way: if the police routinely did its job, then we could routinely do ours. But frequently, and especially if you're in criminal defense, you have to do a whole parallel investigation to find the actual relevant facts frequently. And yes, it does involve a lot of detective work. Do we consult private detectives? Yes, sometimes there are some lawyers who would do that. I find that may not always be necessary, because for the, I don't know if it I may sound a little politically incorrect, but let me put it this way: private detectives are good for surveillance work, if you need to put somebody on surveillance. But if there's actual detection that is to be done, then, well, let me say you need to do it yourself, because that skill set is so unique that most police officers don't lack that skill set. So that is why detection rates and conviction rates in this country are so low. So detective work you have to do yourself. It's yeah, that's part and parcel of criminal practice, or even civil practice for that matter, because you need to find the facts on the ground and verify them. So yes, but is there a specific question you want to ask in this regard?
No, my question was this: that that do you hire private detectives? But what you said, you answered that question very clearly. That most of the time the detection work specific has to be done by you yourself, and not so much by you do not rely on private detectives much. This is very interesting. Of all the other lawyers I've spoken to, you're the first person to say that you have to do a lot of detection work.
There's no doubt about it. And if uh, just to summarize, it's if you need surveillance, there are people better and more skilled with more time and equipment than lawyers that you can hire. But for detection, it's mostly you. And yes, you do have to do it.
So do tell me about the case that you were talking about. I interrupted.
Sure. So, like I said, what we did is we first obtained the email IP headers that uniquely identified the timestamps of the sender and the recipient and the IP addresses. And then using so we got the email headers from Google, because there is a mutual legal assistance treaty between the United States and India that allows our recognized detection agencies to send communications to them asking information requests to Google and Facebook and Hotmail and everybody, and they respond. Well, Hotmail is now Outlook, and they respond frequently within 72 hours, satisfying such requests. And I routinely deal with cases in which this MLAT has been activated. Excuse me. And so after we obtained the IP headers and the IP addresses, we uh, contacted the internet service provider. We obtained the logs. They were natted logs, if you're familiar with natting. And then we wrote a little script. Actually, I wrote a little script, and I was able to narrow down that one particular log with the IP addresses, in which the mobile directory number, which is the unique number given to a particular connection or dongle that we frequently insert in laptops. We uniquely identified that particular connection, and then we got the customer application form for that connection, and that revealed the address of the connection owner, who happened to be the father of the investigating officer. And I still remember his address. It's in North Delhi, and I remember going to that address, and it's a sort of an undeveloped irregular colony of Delhi. It's a very large one at that. And I remember walking through its lanes and by lanes, some of which may have not seen sunlight in a decade, and finally coming upon that house, that particular address. And I remember reading the nameplate on the door, and it had that Delhi blue and white Delhi police, blue and red Delhi police insignia on it, and the name of the investigating officer. So I so I clicked a photograph of that, and the next day in court, we were in Supreme Court, I showed it to him, and he realized that the game is up. And well, let's just say that that was a crucial piece of evidence that helped ultimately absolve my client.
Open court, or did you just show him personally?
I'm sorry, I didn't catch that.
I'm saying, did you actually ask that to him, showed that evidence in open court to him, or did you ask that privately?
Well, we didn't do it in open court. We didn't have to, let's say, but it was as dramatic as you can imagine. It was very, very interesting.
Totally, I can imagine. That's a very different skill set than most criminal lawyers would be having, or different kind of service, I would say. So, so how do you, like, I guess most clients who come to you wouldn't be expecting this kind of a service or this kind of a strategy. So how do people get to know about you, or what you exactly do? Because this is not very standard criminal litigation work.
Yes, that's a good question. If you'll allow me, I'll split it in two parts. One is how do people come to me, and the other part is how do they even know that I do this? And so let me put it this way. It's people don't. Unfortunately, in our field, fortunately rather, the process, the ethics don't allow you to advertise, which is a good thing, I think. And so it's mostly word of mouth. And the other aspect, I suppose, is that there is fortune, is luck, that I got cases in which IT related aspects played a crucial part. But let me put it this way: by 2014, about 4 years into my practice, there were clients that had already started coming to me for IT related cases. So I'll give you an example. In 2014, there was one particular client that came to me. The case was a DRI case, the Directorate of Revenue Intelligence. They had seized, I think, about 200 kilograms of ketamine, and it was an NDPS matter, the Narcotics, Drugs, and Psychotropic Substances Prevention Act, and those are very serious charges. I mean, the guy was faced with 10 to life in terms of imprisonment, and his only defense, well, I wouldn't say it was his only defense, but one of the three pillars of his defense was that he was not present at the spot at which the DRI claimed it had arrested him. And that, if for anyone familiar with NDPS, makes a world of difference under that act, because it sort of activates Section 50 and search and seizure related safeguards and protections that are built into the act. And it would have meant that there was a violation of those protections and safeguards, and it would have meant a crucial blow to the prosecution. So this client approached me because he wanted to prove that he was not at the place where the DRI had in fact shown the arrest to have been effected. And he came to me and he said, "Sir, my problem is that if you can pull the cell phone, the call data records, the CDRs, and the cell phone tower location records for that particular date, then they will guaranteed show, and not just one phone, the man used to carry 3 phones. And he said, all 3 of my phones will show that I was not in fact at the place where they have said I was arrested." And key to the evidence, or rather to the allegation and evidence of the prosecution, was not only that he was arrested at that particular spot, but that the phones were recovered from his person at that spot. So if the phones could be shown to be somewhere else on that day and time, then the DRI's claim would be false. And one crucial aspect of the prosecution would fall apart, and it would bring the whole evidence under a cloud. So therefore, he came to me and he said, if we can get my cell tower location, I can prove that I wasn't there. And I said, what's the problem? You should easily be able to obtain your own tower records. And he says, I could, but unfortunately for me, the statutory period for the maintenance of these records has expired, because at that time, I think it was the UASL guidelines, if I'm not mistaken, which applied to the maintenance of records. And one of those clauses, I think it was clause 48, if I'm not mistaken, specified that such records would be maintained for a year. And now it had been 2.5, I think 3 years by the time he had approached me. So he had moved the appropriate application in the court under Section 91, and the court had allowed his application to produce those records. This is the trial court. The case was from Hyderabad, and the trial court had allowed the application and had issued summons to the nodal officers of the 3 cell phone companies, cell phone service providers. And the nodal officers had sent written communications replying that it's been 2.5 years since that date, and we therefore are not mandated to retain the records, and so therefore we cannot produce them. Crucially, in their reply, they did not say that we do not any longer possess these records. They said we are not mandated to maintain them, and therefore we cannot produce them, without denying the existence of the records. So my value add in that situation was that I drafted an application to summon the nodal officer and to examine him on oath. And in that application, because of the way it was drafted, there was a direct indication to any person reading that application that we were very, very serious about obtaining these records. So what I in fact put in that application was things like summoning the RAID database, the redundant database that these people maintain in separate locations, which has a full backup of the present database of calls and logs. And additionally, I said I want to summon the DBMS, the database manager, and I want to ask him a bunch of questions regarding the scripts, and I want him to produce the overwrite scripts and show us the policy for data preservation in software, and show us the SQL or whatever other language they were using to manage their database, show us the actual scripts. And not only that, I said you produce the redundant database and we will do private forensic analysis on it. And that sent a very clear message to them, that to the nodal officers, that we were serious and that they would have to appear in court and be examined on these lines. And nobody likes that very much because it's very inconvenient. So on the date that they were scheduled to remain present, they produced the records. And because those records clearly showed that my client was not in fact where the arrest was purportedly made, he was eventually found not guilty and acquitted. So this is just another example of how IT works. And by 2014, I suppose people knew enough to know that I can, in fact, provide this sort of value add. And they had approached me. Yes, so a lot of cases that I do, I suppose, because of my 2G background and my engineering background, people sort of expect that I can add some software value to it.
I can totally see that, because I think most lawyers wouldn't know about these things and they'll be at a significant disadvantage compared to you. So that shows the power of the hacker meet lawyers back lawyer. So it's fantastic. I think it's amazing. I mean, I think you should share this knowledge more widely with the larger legal community. Many innocent people will be saved by that.
Well, I'll be out of a job soon then.
I really doubt that. Nobody loses their job by teaching others. It increases your value, in fact.
Yeah, I agree with you.
So I think that's really some really fantastic insights you have just shared. I would want to know more about this. As personally, I'm very curious that how does this process of acquiring this caller details and call details and location details, how does it work? Like, let's say if I am accused in a case, or let's say there's a, I think apart from criminal cases, even in matrimonial cases and a lot of other cases, civil cases, maybe labor cases, because there are many false allegations regularly made, which could be disproved through the use of this technology and even other technology data, related to emails, phone, Facebook. So how do you get this data? I mean, what's the system? And you shared already about the mutual legal assistant treaty and all, but if you could just tell us a little bit more about this.
Well, how you get the data, it depends on what data you are seeking. Typically, in a criminal matter, you would activate provisions of the CRPC like Section 90 or 91, and exercise your right to summon relevant data. You would have to demonstrate that that data or the information that you are seeking is relevant and that the party you are seeking it from is in possession of it. Under civil law, you could use the discovery proceedings. It's 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 vital to have this to have knowledge of the operating principles of this data. And so incidentally, my one of my first experiences with this provision or these provisions of law was in 2G, in fact, which is where I cut most of my, which is where I cut my teeth in law. Most of my practice in trial, my understanding of trial law comes from those cases, and then the cases that I've done thereafter. And in these cases, I have routinely resorted to some provisions of law that, for some reason, are not as routinely applied as one would expect, because it's not that people are unaware of these provisions. They're there. They have been used. They're in fact more often used by the prosecution than by the defense, and that's another curious irony. But when those provisions exist, and Section 91 CRPC is an excellent provision. If you read that, or if you read, I think it's Order 11 in CPC for discovery. If you read these provisions, they are directly to the point on how you can use the process of law to obtain relevant information. And the procedure exists. Courts are willing to entertain these requests. They are absolutely very applicable in cases such as matrimonial disputes, or in fact in any dispute of so here's the thing. Today we are in a post-millennial world. We are very heavily digitally inclined. We use technology every day in almost everything that we do. We're using technology right now. And how would you prove this conversation happened? In matrimonial cases where there are allegations of infidelity, WhatsApp, Facebook is routinely used. And there are spouses that are resorting to installing very highly sophisticated, sometimes subscription based spying tools or apps on each other's mobile phones that will give no indication and leave no trace of the fact that they are actually logging every single byte that's going in and out of your cell phone. And technology is so vastly used today that it's going to uh, not going to, I suppose it already has uh, left an indelible imprint on the way that we lead evidence in court every day. And everybody from the National Investigating Agency and the CBI to private parties engaged in matrimonial disputes are routinely resorting to technology to prove their cases. So yes, the provisions of law do exist. Uh, to go back to circle back to a point you made a little earlier, there are, according to me, inadequate safeguards to how these rights are, to how these provisions are utilized. Insofar as these provisions are used by private parties, they are governed by courts. Uh, but I can tell you that investigating agencies um, routinely intercept communications, private communications, and private data. And in my opinion, the safeguards upon don't exist insofar as these agencies are concerned. And we are in fact working on a petition to get to somehow precisely bring these safeguards in.
I think there was a case a few years back where when Arun Jaitley was
Yes.
the I think the head of opposition, the
Yes.
leader of opposition, and his call details are opened by a police constable from Saket police station or something,
Yes.
and then distributed. So I know, I mean, these are happening a lot, but what do you think the police can do? There have been a lot of rackets related to this, and people, instead of going to the court, sometimes have themselves, reached these kind of rackets and obtained the call detail reports of their, their business partners, wife, or even like their business competitors. Corporate espionage has been quite prevalent in India, although most people don't know about it. So, what can we do to protect ourselves against this kind of things?
Well, to add to your example of Arun Jaitley, I can is Neera Radia, if you remember. I think because in the 2G cases we had, I don't know, five gigabytes of communications or something between her and various persons. And yes, corporate espionage. The reason I brought her up is corporate espionage and things like that, right? So there were allegations there as well, and it. So yes, there is an abuse of process, and that abuse of process happens because the law in terms of safeguards is inadequate. Now, let me be a little more specific. The law that governs, for instance, interception of telecommunication, that is cell phone communications, for instance, is under the Telegraph Act. And this act is more than 100 years old, back when there were telegraphs and they were relevant. And that act, of course, has been amended from time to time only insofar as it provides the police agencies more and more powers to intercept communications, and without actually providing for any safeguards to that effect. Which is, so for instance, if you or I are being intercepted right now, there is no way for us to know, not only today but not ever. And if you contrast this with, say, the United States, for example, under its FISA courts, so they have specific courts and a specific enactment uh, which govern both the collection of this data, and its there is an oversight authority that determines whether or not you are even authorized to collect this data. So obtaining someone's private data, private telephone communications, for example, in the United States, the procedure is very, very lengthy and very strictly interpreted. And there is it's in the nature of a search warrant. You can't take somebody's data without obtaining a warrant. And in India, there is no warrant procedure for this data. The way that all that the police agency needs to do to start tapping your phone tomorrow is that the competent authority being the commissioner of police in a metropolitan region, is simply to pass a written order saying that this person's telecommunications require to be intercepted.
It's just an email usually, an email sent to the ISP saying that, can you.
That's basically it. That's all. Now, is that really a safeguard? I mean, is that, and Can anybody with a straight face in this country say that that these investigating agencies are always acting bona fide? I mean, it's
Recently, a case that came to our notice where a racket was using the email ID of the police commissioner.
yes, yes, yes,
Basically, some other police head constable or somebody was sending emails to the ISP
absolutely.
ID, and the commissioner had no idea.
Absolutely, that's absolutely right, and I can tell you that's the only case that may have come to your to light insofar as you know. But I can tell you there are hundreds, if not thousands, of other cases out there which are exactly like this. And so, for instance, one very simple safeguard I can tell you. One simple safeguard off the top of my head. I mean, there is an entire petition that we have designed in order to introduce more transparency and uh, uh, genuineness in such investigations. One simple safeguard would be that if the information of someone has been obtained by way of intercepts, if that is the case, then after a statutory period, that person must be informed that his telecommunications were the subject matter of interception from this date to this date for so and so purposes, and that we no longer need this information, because unless you intend to institute prosecution against this person, in which case you would necessarily produce this data in that court. So if you choose not to initiate prosecution, you must let that person know that he was tapped or he was intercepted, and that this is his data, and that he has a right to delete it or have it deleted from our servers. This simple safeguard would eliminate a constable from Saket police station attempting to get Arun Jaitley's information, because Arun Jaitley 6 months later, or a year later, or 3 years later, whatever time later, would eventually be intimated that his phone was being tapped from this date to this date, and here is his data. And an investigation would follow. And that constable could not only lose his job, he'll go to jail for it. But this safeguard doesn't exist, because in our country the we have our criminal digital criminal evidence related procedure is not yet fully mature. It's on the way.
I think what you are suggesting is a very much need of the hour. Uh, Given that the amount of surveillance that the state is putting us under, this is absolutely necessary. But do you think that it's likely to happen given how much political interests are involved and that politicians use this regularly, and perhaps the state uses it against its political opponents?
Well, a political question. So I don't know politically convenient to anybody. There is an echo.
Is there still an
No, not anymore. No, there's no echo anymore. Yes. So as I was saying, the your question is in part political, and politically it does not seem expedient or in any party's interest, because everybody exploits the same tools when they're in power. So perhaps politics may not be the way, but as with the case of right to education and right to information and things like that, there could be a judicial way to advance this agenda, and that would amount to tinkering with the engine of our democracy, which is why I'm here. So there you go. There's a full circle.
great? So I hope that you succeed on this agenda, and it's definitely something we need people to work on this and to think about this.
Thank you.
Thank you. What would you say is like we definitely that kind of the topic today is the 2G case. So what would you say was your experience? You worked for several years on this case, and what was it like? I know it's very less time to describe everything, but if you could tell us a bit.
Well, sure. So, I think there's an echo. Yeah, I think the echo is gone now. So, what was 2G like? Well, I'm writing a book about it. Maybe you can read it in more detail in that book when it comes out. It was unique, I can tell you that. It was it was exactly what I wanted, what I was looking for. not in terms of the result, but in terms of the process. And if you can imagine a wide-eyed bloke from engineering who suddenly decided to switch to litigation, and then somehow on day one found himself hyper immersed in in what was the most uh, scandalous of scandals at that time, then if excitement was what I was looking for, I sure as hell got it. And it was very exciting. I had the privilege of witnessing the best lawyers in the country come routinely to court and conduct cross examinations and argue complex legal propositions and substantiate it with case law and with logic uh, with a certain Aristotelian ability to turn things around and twist them. It was remarkable. I loved witnessing every day of it, and I made sure I was there every day of it. And yes, it was very exciting. It was in terms of a learning experience, I don't think I could have possibly asked for anything better than that. It was a phenomenal opportunity. I sort of grabbed it with both my hands and my legs. And I learned most of my criminal law from those cases. And it was in terms of a legal journey, I can tell you, especially in terms of the result. It sort of the result was quite anticlimactic, but every day during the trial was a climax, because it was very interesting uh, on the law and on how witnesses are examined and uh, how complex legal propositions are argued. And it also, in a sense, opened my eyes to how our system works. And I'm not speaking merely of our judicial system or our investigative system. It also opened my eyes as to how our political system works, and how major how politically connected persons can get away with a lot of things in our country. And it exposed me firsthand to the corporate bureaucrat politician nexus. And that nexus is to my mind uh, a festering sore in the democracy that India has. And um, in many senses, like South Africa, I would say in India, my considered opinion is that if we are on the verge of a corporate takeover of our democracy, and if that hasn't already happened. And we need to be alive as a population to the dangers of vested interests and corporate lobbying, and how far they can take policy from its real goals, and how far they can detract from the goals of democracy. And that became very clear to me in the 2G cases. So yeah, it was quite exciting. I'm writing a book about it, like I said. Good time to plug a book, huh?
To plug a book, huh? Yeah, definitely. So I'll ask you more about the book soon. But we get the perception from the media that the defense did a great job in 2G case, but the prosecution didn't. You were on the prosecution side. So what was your observation? And there's this whole story about how the prosecution let them go. So what do you say to that? I mean, I know it's a perhaps I hope it's not too tricky a question to ask, but I really wanted to hear your thoughts on that.
No, it's not tricky. In fact, so a conversation of this nature is very short to explain how tricky the case in fact was, because your question is fairly straightforward. It's the case that was tricky. And so let me hazard an explanation. One is that there is no taking away from the hard work that the defense put in. They really worked hard, and I mean, uh, respect where it's due. They worked very hard, and um, I would have gone as far as to say they earned the victory that they did, but I won't, because um, without imputing any ulterior motives on anyone, I can say that while I was uh, party to the case, while I was assisting the prosecution, and that was through the whole thing. Um, in my own experience, I witnessed at least three direct attempts at scuttling the entire prosecution, one of which was directly from the director of CBI himself. And this is perhaps the only case, not perhaps, it is in fact the only case in the history of India in which the director of CBI was barred, was prohibited by the Supreme Court from interfering in his own department's investigation. This has never happened before. Subsequently, he has been charged. He has been he has there has been an FIR registered against him for interference with the 2G in the Colgate cases, if I'm not mistaken. And it is certainly the only case and was unprecedented in its actions. And I remember there was an occasion when Mr. Anand Grover, the then Special Public Prosecutor, and two of his juniors and myself and another and our we had we had so number two in our hierarchy was Mrs. Sonia Mathur, and she was the standing counsel for the CBI in the Delhi High Court, and number one was Mr. Grover, and after Mrs. Mathur were the two public prosecutors of the CBI, Mr. Goyal and Mr. Rao, and myself and two of Mr. Grover's juniors were assisting the prosecutors, these persons as prosecutors. And in this chain of command, Mr. Grover, Mrs. Mathur, two of Mr. Grover's junior, and myself, we on one occasion went to the CBI headquarters and obtained files which belonged to the confidential investigations conducted by the CBI, confidential files. And we read those files, and this was all under the authority and instruction from the Supreme Court. And when we read those files, we found written notes by the director, which we believed constituted a direct interference in the 2G prosecution, wherein the director in fact admitted practically the entire defense case. And we then put forward our opinion in the Supreme Court, and the Supreme Court ejected the director from the 2G cases. So it was by no means a simple matter of mere evidence. I can tell you that there were several very political attempts, very direct attempts made at scuttling the entire prosecution, and I've endeavored to write a little bit about them in more detail. But in terms of the evidence, I mean, if you ask me why we lost, why they were all acquitted, if I had to hazard an oversimplification of the result, I would say this, that in the end, the judgment reflects a basic misunderstanding or misappreciation of the simple concept of first come, first served. The whole case was that the Department of Telecom operated on a first come, first served basis. And during engineering, I remember learning FCFS, first in, first out, right? And all this means is that the first to apply would get the license in the end and the spectrum in the end. And instead of first to apply, the allegation of the CBI was that A. Raja, accused number one, the then minister, changed this from first to apply to first to comply. That is, now the first person to comply with the conditions will get the spectrum, not the first person to apply, thereby rendering null or zero the concept of first come, because it's no longer first come anymore. And in that sense, I mean, if I have been clear here, I suppose there must be a failure, because we were not able to explain to the judge how first to apply is simply not the same as first to comply. And his entire judgment reflects, in that sense, if I may respectfully disagree, he may have missed that point.
Yeah, but in the end, like, he claimed that there was no evidence presented to him. He said, I waited and waited, and no evidence was given by prosecution.
Oh, that was weird. I can. He had more than 4 lakh pages of evidence. And I can tell you another thing, this whole case is documentary. There is no, I mean, witness testimony has only so much value because the case has so much documentation. It's so detailed and it's so clear that I must respectfully disagree with the judge. I think he's got it absolutely wrong. And I feel in that sense that the prosecution has been scapegoated because perhaps the judge missed the point.
Do you see any chance of this getting reversed in Supreme Court at some point, or this being taken up later?
I hope so, because there are a lot of important issues involved in this case that I believe the time has come to, because the so for instance, one of the important issues in this case is that most people who haven't studied criminal law may have missed is the allegation of 406, which is or 409, which is criminal breach of trust by a public servant. And the law as it stands under two common cause judgments of the Supreme Court from the 90s is that a minister in charge of a portfolio cannot be held to be in the position of a trustee, which is that he has not been entrusted with any property. And because he has not been entrusted with the properties that entail his portfolio, therefore he cannot be held to be in criminal breach of trust because of the lack of entrustment. And I think this doctrine is outdated, and I don't think it applies in the context that we today operate in. And I think that it uh, it absolves the minister of or any minister of his primary to ensure that the properties that vest in his ministry are managed properly in the way of by way of an entrustment, by in the manner of an entrustment rather than in a profligate or irresponsible or arbitrary manner. So I think that doctrine needs to change, and because of this verdict, that doctrine, the question of law is still open. And I think that the Supreme Court, when this matter, if not if but when this matter does go to the Supreme Court, it will have a unique opportunity to revise that doctrine.
Very interesting. So, what would you say is that after like, did you go independent after that? How did it happen? Like after the 2G case experience?
Yeah, I went independent 5 years into the case. The case lasted for 7 years, and about 5 years into the case, I began my independent practice. I never intended to actually practice in Delhi. I'm a Bombay Pune lad. I'm not from Delhi, and my name Borwankar makes me squarely from this region of Maharashtra, and so this is where I intended to practice. In fact, originally I had intended to practice with Mrs. Rohini Salian, who was the standing counsel for the NIA in state of Maharashtra in 2000, in the first decade of this millennium, and I had a secure position. I had already spoken with her. I'd interviewed with her, and she had accepted me to juniorship in the month of July 2011. And uh, I remember asking Mr. Lalit at that time, who was the then special public prosecutor. I said, "Sir, how long do you think this 2G case will last?" So he said, "Oh, 6 months, it'll be over. It's day-to-day trial." And I said, "Okay, sir, 6 months." So I went back to Mrs. Salian and I said, "Ma'am, can I start 6 months from now?" And she said, "Of course, you start 6 months from now, no difficulty." And 6 years later, I still found myself in Delhi. So I realized around 5 years down the line that this is going to take a while, and I need to earn my bread and butter. And the CBI, while it did pay me, it's I was not on a day, it was not a regular salary, it was not a monthly salary. So I had quickly burned through all my savings from my software days, and I needed to work. So after about 5 years, I started branching out on my own, and that's how I got into independent practice.
Great. So, what was the experience like to transition into independent practice from those days? Like, what were the challenges you faced?
That's a good question. So it took me a while to realize it. Maybe I'm just slow, but it took me a while to realize the entrepreneurial aspect of starting your own independent practice. So one of the first realizations I had is that this is now a business, and in a business you have to professionalize your setup, you have to professionalize your workflows and processes, and it takes a while to build them, because when you're experimenting, and you lack certain inherent advantages that some of your competitors may enjoy in the profession, which is frequently in the form of some parent or spouse or relative already being in practice in litigation. and a well-run, well-oiled setup helps. I mean, something as simple as finding a good clerk is one of the things that you learn early on the value of. And uh, not only does he have to be competent, he or she has to be competent. They have to be well-oiled. And and when you are starting out, you have to have a vision, because you don't have the money, that's for sure, if you're a first generation lawyer like I am. So you don't enjoy the inherent benefits of a well set practice that your relatives or parents may have. So in that situation, you have to have a vision. And if you have a vision, you have uh, to be able to share that vision with your, even with your clerk and with your juniors or your interns. And that vision, I suppose, comes from clarity of thought. And because I suppose I had this clear thought in my mind that I'm going to spend my practice tinkering with the engine of democracy to see to what extent I can fine tune it, or contribute in its fine tuning. I had a vision, and translating that vision to each person's level is one challenge. It's an entrepreneurial challenge more than a legal challenge. And so it's one of those other aspects of entrepreneurship that I was slow to recognize, but it does exist. So processes, systems, professionalization, and a vision, these are all aspects of entrepreneurship and of creation and of the joy of creation that I suppose I in some way duplicated from my software days. So is this, are you still there?
Yeah, I think we lost you for a second, but no problem. So, how would you say can you switch off the microphone for a second? Nikhil, can you switch off the microphone? Yeah, okay, thank you. So, I was just asking, what kind of practice are you trying to build, and what's the experience of that? Uh, you're building a large practice with many lawyers under you, or is it you and a few more people, or you are independent and alone? How does it really work for you?
Okay, so the I started out with essentially myself. I did my own uh, clerkage, so to speak. I did my own filings. I did my own dealings with the registry. I pushed my own applications, and I learned from that process. And then I found a clerk because I could afford one by that time. And as my clientele grew, so did my staff. And presently I can without hesitation say that I have the most motivated and driven set of juniors. There's now six of us in total. That anyone would have the good fortune to have. They are just driven people. I mean, we have managed to file petitions within 24 hours overnight in the Supreme Court and in the High Court, and get relief. And this bunch of boys, they accept this vision, they add to it, they contribute to it, and uh, they're excited by it. They are excited by this exposure to the engine of our society, and they like being in the driver's seat, and I enjoy watching them do that. So it's it's a it's a virtuous cycle that I have been fortunate to be able to set up. I have excellent staff, very competent, very motivated, self-motivated, which is rare to find, and they are willing to work for less because there's not so much I can pay them yet. But I hope that the practice will grow to a point where it justifies their level of enthusiasm, and I see it headed that way. And so, yeah, there is the practice I'm building is that of an independent practitioner, which is as a first generation uh, lawyer, it's hard. It's unique. It's not unique, but it's hard. It's a different struggle, and it motivates me. It drives me as well. And so the direction that I seem to be headed in and actively working towards is one of uh, of the full exploration of certain kinds of law, especially criminal, and it's exciting.
That sounds really exciting. Yeah, great. Okay, so I wanted to ask you about this. So from that vision, I started an organization with the idea that we need to make legal education accessible, law accessible to people. So I mean, we have feel it. I mean,
Sorry, can I just ask you to repeat because I lost you there for a moment?
can you please switch on the microphone? Thanks. So, I mean, there's some problem. I don't know what is happening, but there's some systemic problem because of which, whenever if I switch on my microphone, then it echoes, and if you switch on yours, it echoes. You have to keep it alternatively on and off. So, what I was saying is that, when I talked to you, I think there was a huge advantage you had of having seen another professional world, a very competent world of software development, and you worked with professionals from the get go when you worked with Justice Lalit or even others in your journey, and worked on a big case. So you have always had the fortune of working with the best and being seeing high standards of work. Unfortunately, in this country, most students don't, or law students or young lawyers don't have it, and it's a huge issue because people do not get justice because their lawyers are not able to deliver it to them. And it's sometimes I would not entirely blame the lawyer because they also were not trained well. They are doing what they saw or whatever they are capable of. And another way I see is that they have say 5 years or 3 years of doing a degree during which they are not really trained for all the things that you're talking about. They are taught some sections and case law and said, now go and fight your case, right? And I think they're inadequately trained primarily. And if you get a good training from your senior, you get fortunate enough, you have the right connections, you get to work with the right people, you learn. Otherwise, you don't. Or even if you work with a great lawyer and he doesn't have time to teach you, then well, too bad for you. I mean, people really, whoever learns, either they are self-driven, self-taught, or they are modeling themselves around somebody they are getting to see. How do you think? Because I can see that you have a design thinking. You think like an outsider, not so much as a lawyer, perhaps. Like you bring that perspective where you are trying to with the way you say. How do you think that what's the way forward? Really? Like, are we doomed to have a class of lawyers where they will not be trained, they will not be competent, and therefore drag down the entire justice system?
Oh, are we doomed to have lawyers that may suffer from inadequacy of training? Well, that question could perhaps also be put in another way. Are we doomed to have doctors of that nature, or engineers of that nature, or scientists of that nature as well? And yes, there is a danger where there is certainly a difference between theoretical learning and practical learning, and there is unarguably a gap in practical learning in colleges and in terms of our course design. But if you see some of the institutions,
Just wanted to add one thing. If you look at doctors, they at least have to do their practicals, and there's a hospitals attached. I can't say the same thing for engineers, unfortunately. But you don't not every person has to go hire an engineer. Like there are companies who are sophisticated enough to tell if you're good enough to train you. But imagine the problem of the person who's gotten into a legal trouble, somebody's land is being taken away, or gotten into the kind of problems you've been describing, somebody falsely accusing them, and they go to whichever lawyer they can find. Literally, they can't differentiate always. There are clients who are sophisticated and can tell which lawyer they should go to and which not, to whom should not go. But I think this is a little different than scientists and doctors. And like, law presents a unique situation in terms of that if there's a lawyer, you go to them and you entrust your life and property and whatnot to them, literally, like, so I just wanted to distinguish.
Sure, yes, I agree with you. There is certainly a distinction there. Uh, there's two parts to your question. Ideally speaking, in an ideal judicial system, you shouldn't require lawyers. Um, but we have evolved as a species to understand the adversarial system to be the most effective, or at least believe that it is the most effective. And so, after 5 or 1,000 years of systemic evolution, and our ultimately manifested in our constitution, we have an adversarial, semi quasi adversarial sort of system of justice. And uh, in this system, undeniably, lawyers play a very crucial role. Now, how do we look at this role in terms of professionalizing it? So, one way to look at it would be, say, how the British look at it, which is there. So, if you want to practice in the UK, you have to go through a BPTC, which is the Bar Practitioners Training Course. And that necessarily involves a 2-year apprenticeship with one of the established chambers. And they have a chamber driven system, and they have an inn driven system. You have your inns of court. And if you look at our system by contrast, and in terms of its design and architecture, it was designed to be a little more uh, liberal, a little less elitist in its design than the British system, than the British system is. Now, whether that has manifested in injustice at the lower level is an arguable point. But there is no doubt that we need to increase the proficiency of and the professionalism uh, of all segments of our and strata of our lawyers. And one way to do that, I suppose, the Bar Council of India has taken a positive step. I actually agree with the concept of an all India bar exam. It's just the first step, and it needs to head in a direction which is similar to the United States, where you have a very strict bar exam where only the best get through, or at least the most proficient get through. Because I may lose a bunch of friends for saying what I'm saying, but I think it's a positive step towards a more professional uh, profession.
So that's something interesting that I want to comment on from personal experience. So I have been running a bar exam training course from the first bar exam in 2010, and so as an experiment in 2000, I think it's 13 or 14, I asked my graduate student, who's just he's not even an honors graduate. He passed BA that year and Bachelor of Arts. And I asked him, "Can you try this paper? This is I was reviewing it for Bar and Bench that year. I remember I wrote this in that review. I said that, can you just take this test, and I want to see how you do." And I gave him the bar exam paper, and he wrote it, and he scored a 70 on it. And he had never studied any law in his life. And he did not have the books. It was an open book exam. He didn't have the books to answer from. And I think most people who are giving the exam, sometimes people ask me, why do you run a bar exam course? Do people need a course to pass the bar exam? That's ridiculous. And I say, yes, you wouldn't believe there are lawyers who take this course. Some of them take it because say they were working abroad and they forgotten the provisions and they want that. There are people who are working, let's say, private equity day and night, and they've forgotten their CPC, CRPC. They want a quick revision, whatever. But there are people who fail the exam once or twice, and then they come to us. And I don't know why. Why would anyone fail? Like, there are at least 40 questions in the bar exam which directly ask which section says XYZ. So you have to just open the act, and there are 4 options, You have to check one by one those sections from the Bare Act, which one talks about that particular thing, and that's the kind of barrier you are setting for selecting. So the concept, I agree with you that the bar exam is probably needed, but the kind of bar exam you have is also important. I think the bar council is literally looking at this a way to earn some money every year, but not stop anybody from becoming a lawyer.
Well,
If at all the bar,
I are agreed on the concept, then at least there we are in agreement. But let me put it this way: there is let's not be impatient. This is a democracy. If we start off with an exam that fails 99% of those that appear for it, then I don't think that exam has a future in its second or third year. So it's gradual. It takes time. We need to be more patient as a citizenry and appreciate the good step that has been taken, and argue for its constant optimization, which is exactly what my practice is all about. It takes time, it takes a while, and you keep tinkering with it till it gets to where it needs to be.
okay, with that optimistic note, I want to ask you about, how do you find time to write a book, and what are you exactly writing about?
So, compounding my issues with time is the fact that I also have, with a bunch of, with quite a few of like-minded individuals, we've started an NGO. It's called AVAKE, Action for Vigilance and Knowledge for Empowerment, and that also takes up a fair bit of time. It's this AWAKE is an NGO which is designed specifically to achieve the objective of optimizing our engine of democracy. And the book I'm writing, in the sense that it is correlated to correlatable to this, is that it's precisely along those lines, which is my experience not only with the trial, not only with the actual evidence and the actual allegations that I believe most people are unaware of, but it also goes one step beyond to explain what I have learned about how our engine works today, and why I believe our engine is driving us in the wrong direction unless a course correction is brought about as soon as possible. And the book, therefore, sort of laces these two or interlaces these two concepts together, which is and a third aspect of that book is a bit of my journey as well, is how I came to be where I am, and what I did, and what I observed while I was doing it, and what I have learned from it. So those are the aspects that I think need to be out there in the public. The Our people need to know, because democracy dies in darkness. So uh, if I believe that the more people are aware of how the bureaucrat, politician, corporate nexus actually works, the more details they have, the more they know about how bankers aid these people, and why a Vijay Mallya or a Nirav Modi can happen, and how banks and branches are manipulated into conducting thousands of crores worth of transactions in a single hour through dozens of companies without triggering a single money laundering related safeguard, and how CAs, the chartered accountants, aid these corporates in setting up shell companies, and how they create complex and opaque webs of cross holdings that lead out of India into the Virgin Islands, into Cayman Islands, into Mauritius. And why I mean, somebody has to answer the question why there is so much investment through Mauritius, and frequently the answer is double taxation avoidance, and I think that's all hokum. I don't buy that for a minute. The reason companies, I believe, are investing so much of money through these tax haven countries is because those countries also have laws that allow opaque cross holding structures, such that you can never really find the true owner, you can never really know where the money actually went. And these are elaborate international money laundering rackets, if you ask me. And something needs to be done about them, but something can only be done if our people are aware of how these machines work. And my book is in that sense an expose on how these networks of the elite work around the world, and how they are able to subvert our processes and our laws.
I completely agree with the objective that you have, but I have a fear, and this is not any way to. I think what you're doing is fantastic. The work you're doing is fantastic, and this book sounds very interesting. I'm definitely going to read it. But I have this fear that somewhere WhatsApp is winning over books. And when you talk about complex things, people don't want to hear. They want that that one diagram with the face of two political leaders pasted on both sides with numbers below that. And somewhere there's oversimplification that is going on, and that is winning somewhere, because earlier you could make a complex point and there were few people listening to the media, few people, and most people were not part of it. But now you have like this huge uh, few people who have come on the internet, on phones, on WhatsApp, on Facebook, and there's a information war going out over there right now. It's a war of people trying to influence, misdirect, uh, spin stories, misinform. It's like you can just write any sensational story today and have it go viral. And we saw that during the even in the US, where actually people are probably, I think, education levels are higher than in India. Uh, how do you counter this? Like, do you think writing books, or even like maybe you're talking for that, probably you're talking even in the wrong language? What's the future? What's going to work out? What's your view on this?
Well, how about I make you a deal? Let's make a 12-part Netflix original, and you can help me market it. No, no, that's. I think that there is no doubt that there is an information war that is happening out there. The reason that information wars are possible is because there is a large segment of journalists or journalism that is no longer committed to the truth, but rather committed to a propaganda and a point of view. And once you are committed to a point of view, did you want to ask me something?
Okay, I think now can you hear me? Yeah, so I was asking that, do journalists even control media anymore? Like, I don't think the official media that used to kind of drive the stories do even work today. Like, it's more like there's a invisible flow of information through WhatsApp, through Facebook groups, and I don't know what else. Like, I probably don't even know of share chat, maybe. Like, there are all these things that we don't even use perhaps. Like, there's like there's a lot more information being consumed and trusted, more trusted than the mainstream media. Like, it doesn't matter what NDTV says today, but if your 10 of your friends are sharing a share chat message with you, which is actually a new chat app that Indians are using extensively. I think they just raised over $100 million. It's an Indian company, like Indian. You can think of a local language WhatsApp company. Okay, WhatsApp equivalent. I know the founders. uh, I think that's where the real information battle is being fought, not on the TV studios as we think. That if we think that we can go to NDTV and influence the opinion, I think it's probably not right anymore.
That's an important issue you raised. So there's two things to this argument here. There's one is the tools of the trade, which may have changed, and the other is the trade itself. Um, Insofar as the tools are concerned, look, even Baba Ramdev has attempted to launch a WhatsApp-like mirror application, and it was pulled off of Play Store, I think, within 4 hours or something. But yes, there are tools out there, and then there is the other aspect, which is the trade itself. Journalism, in terms of its ethics, is undergoing a, an internal conflict. There in the United States, as you pointed out, there is an open civil war in terms of journalism and ethics is concerned, where facts are no longer facts and news is no longer just news. It's fake news versus more acceptable, palatable news. And Um, so, insofar as the journalism as a profession is concerned, I believe that the in addition of new uh, and improved tools of communication is vital, because it serves an important purpose of enabling non-mainstream media outlets and irregular news sharing and committed individuals to reach uh, broader audiences, and it allows persons such as yourself and your enterprise to do the good work that it is doing, which is to be able to reach certain audiences and to give voice to certain persons, perhaps even persons like me, and perhaps persons like the others that you've had the opportunity to interview. And it's important that these tools like Google Hangouts and like Messenger, like WhatsApp, are out there enabling, rather breaking down traditional barriers to mass communication. And when these barriers are broken down, we find a greater democracy in voice, in communication. Now, does that mean that there are persons setting up private forums sharing data that may not in fact reflect the reality? Yes, it does certainly mean that. But the only way to fight information is with information. You can only fight misinformation with real information, with the truth. And in the face of the truth, the lie shall always yield. So we have to have more truth out there. And if that means making a 6-part simplified series on YouTube for it, then so be it. In fact, that I also intend to do that with my book, which is that for those who don't have time to read 1,000 pages, I would like to give maybe a 3-part, 6-minute sort of series that simplifies the issue. Now, does that risk oversimplification? Yes, it does. But you can always counter with data. And the danger is that there may be a lack of patience that this communication engenders with accepting this data. And because if the danger is that if people no longer want to read a 1,000-page book to find the real facts, and instead resort only to 6-minute videos to learn what they want to learn, then yes, there is a danger. I wish that more people are more detail oriented and do attempt to answer basic questions. But at least it engenders debate. At least these tools can also be used to engender real debate and to reach out to everybody and to give everybody a voice. So yes, I think that there needs to be a renaissance both in the profession of journalism, as in law, as well as in the tools of the trade.
Okay, so with that optimistic note and a lot of work to be done on every front, let us end today's session. It is already very late, but I was thoroughly enjoying the conversation. I didn't want to end it earlier. But before we go, do you have any parting message for our viewers?
Yes, certainly.
Yes, sir.
Let me start by first thanking you for this opportunity, and I hope that I've been able uh, to be on message mostly, or clear at least. And do I have a message for people? Yes, I do have a message. I think that, as I said before, and those weren't my words; they were somebody else's. That democracy does die in darkness, and um, I think that people need to have their own personal journeys to ascertain the truth. Look for the truth and you will find it. And I hope that more and more people look for the truth. And I hope that given the exponential rise of technology and of motivated individuals such as yourself, that I hope that more and more medium and media is provided to people to find their truth. And so my message simply is keep your eyes and ears open. And if you see something, say something.
Okay, before you go, I have one question. There are some good comments and one question that I wanted to share. Uh, Vikas is asking, hello sir, Honorable Delhi High Court order regarding illegal de-addiction center in which you was you were a petitioner. What about that? So do you want to say something?
Sure, why not? Actually, there was one. There's a friend of mine. He's a police officer in Delhi, and he sent me a message saying, "What is this writ petition number so and so about? Why you find this?" So I said, "यार, मेरा ख्याल ये था कि इलीगल डिटेंशन का धंधा करने का हक सिर्फ दिल्ली पुलिस का होना चाहिए." सो मैंने सोचा कि ये जो डी एडिक्शन सेंटर्स है इनको बंद करा दिया जाए. So my point that I was trying to make is that I had a case last year where a family approached me and said that one of their relatives had been detained for 2.5 years in a de-addiction center. And I said, "What do you mean detained in a de-addiction center?" And they said, "Well, effectively, his wife made the call and paid these people off, and they arrived in an unmarked vehicle with tinted glasses, bagged and hooded this person, tied his hands up, threw him into the car, and he was never seen from or heard from again. And 6 months later, they found out where he is, and they realized he has tuberculosis and that he's obtaining no treatment whatsoever. And then he developed festering sores. He was dying effectively in there, and he was kept in there like a caged animal." And I said, "That's pretty shocking. Something maybe needs to be done about it." So we moved a habeas in the Delhi High Court. We got him out within 24 hours. And when he was out, he told us a really shocking story about how these centers are run. And then, as we discussed before, we did our own investigations and we found that there are in excess of 170 such de addiction centers in Delhi, which range from cages to luxury five-star related de-addiction centers, and one must wonder what goes on in these centers. And so we did a bit of investigation and we found that a lot of them, in fact all of them, run without any formal regulation because there is no such regulation in Delhi. And we found that in a lot of them there are a lot of persons who are detained against their will simply because somebody else is willing to finance their detention. And naturally it's a gross abuse of law. And so I decided that we need to do something about it. And this was before just before Awake was my NGO, the one that we founded together, was still under incorporation. So I sort of risked it and I filed it in my own name, and I wish I could have filed it in Awake's name. But yes, the attempt there was to uh, stop these centers from any further illegal detention. And in that, I think we have succeeded because the Delhi High Court appointed a committee under the Delhi Legal Services Authority that inspected physically all these centers and found that a significant proportion of persons in there are being detained against their will and not obtaining any de-addiction treatment as such. In fact, it's a mystery whether they were ever even addicted to anything. And it's I mean, you have to stop and wonder whether we're living in a democracy or is this some sort of tin pot banana republic, where such things and centers can be running in the heart of Delhi, in the center of Delhi, in highly populated areas like this. And that's what this petition was about. So yes, I think that we have been successful in that objective, and I hope that you will spread the word. And everybody, Vishal was it, maybe he should also spread the word that these centers are illegal and that they cannot detain anybody against their will.
That I think that's fantastic work, and I'm also shocked to hear about this, and I'm so glad that you have taken this up. And I think, hats off to you for taking up these kind of matters, and that's great. We have a question from Ranjit Singh Power, who's asking, do you intend to attempt for the senior counsel designation when the time comes? I think it's a flattering question.
No, not anymore. There's an exam for it now. No, I don't know. I guess maybe sometime. I don't believe I'm senior enough in practice to even attempt something of that nature. Maybe with time. But thanks for asking.
Thanks for asking. I'm quite sure it will happen now or later. But it was really fantastic conversation, and so I have learned a lot from this conversation. Thank you so much, and we hope to have you back in an hour with LawSikho with a copy of your book on the screen soon. So, and maybe you can read a few pages to us especially for the lazy ones amongst us who's not going to actually read, but be happy to hear some excerpts from you. And really, it was really fantastic. and the kind of work you are doing. I am very happy to hear about it, and I'm sure everybody who listens to this video will be excited. And thank you once again. Look forward to talking to you soon again. And thank you, everybody, whoever listened to this very long conversation. And to come back tomorrow again. So, all right. Thank you. Good night, everyone. Would you like to add anything?
No, thank you. That's very kind of you. Nice words. Thank you. Good night, everyone, for listening. Thank you.